I have finally learned something that we can do about the Nintendo patents that I believe are fraudulent, the ones that they are using to go after Palworld and probably a lot of other games in the future. And it is something that me and you can do. To give a little backstory, just personally backstory, back in April 25th of 2025, I started the Change.org petition, Stop the Abusive Misuse of Patent Law by Video Game Developers. At the time, I was frustrated with what was going on. I thought it was BS. I thought it was unfair, but I didn't really know what to do. And while I recognize and I admitted that a Change.org petition is essentially shouting into the void and hoping that enough people start shouting that someone will finally listen, there was nothing else that I knew of that we can do. And I resolved to find out, and I said I was going to find out more effectual things that we can do, something similar to the European Citizens Initiative, Stop Killing Games type thing. And I admit I dropped the ball on that. I wasn't aware. I didn't fully even know how to find a way to do that, but I did. In the course of doing some research, I found something that we can do that will actually have an effect, or actually could have an effect. It's more than just shouting into the void and hoping that someone listens. And this is directly through the U.S. Patent and Trademark Office. The U.S. Patent and Trademark Office has the Patent Trials and Appeals Board. And as part of the Patent Trials and Appeals Board, you have the ability to file an appeal on a patent. And I'm going to go over what that is. And I'm going to link all of this in the description for you to review at your own time later if you want to. It is called an inter partes review. An inter partes review is a trial proceeding conducted at the board to review the patentability of one or more claims in a patent only on a ground that could be raised under USC Chapter 35, subsection 102 or 103. Subsection 102 is the subsection that covers novelty, aka prior art. Does this exist? Is this a thing that has already existed prior to the filing of the patent? And that's the big one. And subsection 103 covers obviousness. Is this something that, let me get the exact wording here. I want to make sure I'm using the exact wording here. Subsection 103 is obviousness, which is essentially, is this something that someone else could have made? Someone with what they refer to, a person having ordinary skill in the art to which said subject matter pertains. So something that someone with a basic amount of coding skill could easily figure out and easily make, which this is something with someone with a basic amount of game development skill, and this is my interpretation of it, something with someone with a basic amount of game development skill would be able to make themselves, then it is not patentable. It is just definitively not patentable. So those are the two subsections under which a inter partes review can be filed. And then it goes on and says, and only on the basis of prior art consisting of patents or printed publications. So the prior art, and this is something I've discussed in previous videos, the prior art has to be a patent in this case. And in prior videos, I discussed how it seems like the only thing they're really reviewing in all these, in my previous video, I even show it, the only thing they review, I believe I showed it, the only thing they review is stuff that's already in the USPTO database. So if it's not a patent that already exists, they're not going to know about the prior art. So in this case, they're only allowing you to put forward patents that already exist as prior art or printed publications, because we already know that the patents don't exist. They did the searches. As far as we know, those patents don't exist. Prior to this, a lot of game companies that have done similar things, like WoW or Diablo or Ark Survival Evolved or all these other games, never filed for patents for those mechanics, because why would they? That's stupid. It's an idea. Why would you file a patent for an idea? Nintendo did, so when they did the review, those patents weren't there for them to catch. But printed publications is something that we might be able to find. We might be able to go to Game Informer articles or PC Gamer articles or any of these other printed publications that discuss these mechanics, and discuss these ideas and the fact that these are implemented in games, and submit that as prior art for an inter partes review. And then they can use that to determine that, yes, these patents should never have been granted. There was prior art. We screwed up, but Nintendo never should have filed this. So hopefully that will work. But let's go on. More about the inter partes review. On the basis of printed publications, for a first inventor to file patents, inter partes review process begins with a third party, a person who is not the owner of the patent, me, you, other people that I might discuss at the end of this video, filing a petition after the later of either 1, 9 months after the grant of the patent or issuance of a reissue patent, so 9 months after the patent was granted, so that gives us a little bit of time, or if a post-grant review is instituted, the termination of the post-grant review. So if they do a post-grant review, after the termination of that review is when you can start it, whichever one comes later. These deadlines do not apply to first-to-invent patents. This is a first-to-file patent, I believe. After 2012, 2013 is, I believe, when they switched from first-to-invent to first-to-file. The patent owner may file a preliminary response to this petition. So if we do this, if I go forward or I get someone that I'm going to mention at the end of the video to help me go forward with this and file it, then the patent owner can respond. So Nintendo can respond to the petition, basically to the USPTO, and say, hey, this is why I don't think you should do this. This is what, no, please don't. Please don't. How much money do we have to give you? How much money do we have to give you? I'm not saying that Nintendo bribed them. I'm making no official statement that Nintendo bribed them, but it's a joke, guys. An inter partes review may be instituted upon a showing that there is a reasonable likelihood that the petitioner would prevail with respect to at least one claim challenge. So when you see a patent, and I've shown patents on my videos before, there's a lot of claims. As long as there is sufficient evidence that we might succeed on one of those claims, on getting one of those claims overturned based off of prior art, then we can move forward with this. If the proceeding is instituted and not dismissed, a final determination by the board will be issued within 1 year, extendable for good cause by 6 months. So they will, once this proceeding starts, if they don't dismiss this, if they say, yeah, we're going to go forward, we're going to look at this, there's a reasonable likelihood that you will succeed, then they have 1 year to respond, or 1 year and 6 months if there's a really, really good reason, and basically make a decision on whether or not they're going to invalidate the patent. The procedure for conducting inter partes review took effect on September 16, 2012, and applies to any patent issued before, on, or after September 16, 2012. That definitely applies. That definitely applies. So with that, here's what I'm going to do. And here's what I want you to do. And here's what I'm asking you guys to do. I have already reached out to Legal Mindset. A lot of you have gotten into my comments and told me, like, hey, you should watch this Legal Mindset video. He's also talking about this. You should watch this by Legal Mindset. He's also talking about this. Or, yeah, I saw this on Legal Mindset or something like that, along those lines. And I make it a personal policy to not watch other creators talk about something that I plan on talking about. I do not want to watch other YouTubers videos on a topic that I'm going to talk about, because I don't want to unintentionally just parrot what they're saying. And I don't, like, part of it's just personal. Is like, I don't want to feel like I'm not saying that I'm just copying someone else. I don't want to unintentionally copy someone else because they said something and, like, now it's just in my mind, so I'm going to say the same thing. And I don't want to feel like I'm copying someone else. I might be saying the exact same thing, but I'm coming to those conclusions on my own based off of my research, not because I watched someone else say something and I said, yeah, I agree with that. So I don't watch other creators' videos. But Legal Mindset is a lawyer who has also been talking about some of these issues, some of this Nintendo patent stuff and the lawsuit stuff. So one of the things I said when I started my petition, my Stop the Abuse and Misuse of Patent Law by Video Game Developers, is that I would love to get a lawyer involved to help me work on the verbiage, to put forward, like, more official petitions or put forward more official documents or requests or whatever, and work on the exact verbiage of everything. These are the words within patent law that we want changed. This is what we want it changed to. That's based this. The two groups of people I wanted to get involved were a lawyer, specifically if there's a lawyer that was a content creator, that way could help increase the reach so that they can help me work on the verbiage, and a video game developer so that they can help work on the verbiage from a technical standpoint when it comes to video games, because they're going to know the words related to game development that might be more relevant to help get specific words in there that actually have meaning that can be used as a basis. In that case, I originally reached out to Pirate Software. This was before the Stop Killing Games initiative happened. He said he was going to help, or not before the game happened, but before the drama, and he responded in a very inappropriate way, and I became aware of that. This is before all of that. He responded that, yeah, he was going to be a part of it, and then a month later told me no. Or he responded that, yeah, he'd look into it and probably be a part of it, and a month later said, yeah, I agree with you, but I'm not going to do anything about it. It's neither here nor there. Basically, this is all to say, I've already reached out to Legal Mindset, and I'm hoping that he responds. I sent him an email, and posted a comment on one of his videos. I'm hoping that he responds because I would love to start working with him on this. If we could get this going. Update to this, I actually got a reply back from Legal Mindset. He replied back to me incredibly quickly. Like, I recorded this video, I messaged him this morning, and then I messaged him and recorded the video. And by the time I finished recording the video, he had messaged me back. So looks like we're probably going to be working together. So already one win in the victory column there. Already one victory in the win. It's moving forward. So this is pretty awesome. Yeah, back to the video. The next step, and this is where I need your guys' help, is I'm going to make a pinned post on my channel. I want to make a pinned post on this channel. I need you guys to help me do the research. I need you guys to, if you have the time, look through Game Informer articles, look through PC Gamer articles, look through printed publications. This can't be a trailer. This can't be a video. This has to be printed publications that show that other games have implemented these mechanics prior to 2021, because that's the start one for a lot of the December 22nd of 2021 is the start one for a lot of the ones that Nintendo is using to go after Palworld. But other games have implemented these mechanics prior to 2021, and even better, prior to December 22nd of 2020, just to not even have that 1 year statute of limitations for prior art that the US patent system has. And I need you to comment links to those underneath that post on my channel. I know it's not going to let you comment a link. If you comment the title of the article with like the company it's from or the publication it's from, I can Google it, I can find it later, and I'm going to get together as much prior art as possible. I'm going to get together every piece of prior art that I possibly can, and once it is time for me to be able to do this, which according to this, it's 9 months after the grant of the patent or issuance of a reissue patent, and hopefully there's not a post-grant review instituted within that time. Yes, once it is time for me to be able to file this, once that date gets hit, hopefully working with Legal Mindset and hopefully working with a team of people, I'm going to try to file for one of these inter partes review throughout whatever methodology I have to do to make this happen and get this process started. So every piece of prior art that we have access to that we can cite is gonna help. And again, just to reiterate, this has to be a printed publication according to the way that the rules work for this. And the final thing you can do to at least help this a little bit is sign the change.org petition, stop the abuse and misuse of patent law by video game developers. I will link it in the pinned comment. I will link it in the description. I will link it in the post that I'm going to make that I'm asking you to leave these comments under. That post will also be linked in the description and in the pinned comments. That's that. I am so excited to see that we finally, that I know how to fight this. I have felt so stupid being like, yeah, I'm going to, or just like kind of powerless in a way, being like, yeah, I want to do something about this. And the only thing I could think to do was a change.org petition. And I'm real happy how far that change.org petition got, because I didn't think it was going to get, it's at like over 4,000 signers right now. I didn't think it was going to get that far, but it did. I am incredibly excited about that, but it was still just saying we're mad as hell and we're not going to take it anymore. And ultimately hoping that someone would see it and respond to it. But this is an official process. This is something that they have to respond to. This is something that we can do that will actually have an effect on this issue. And this won't necessarily affect whether or not video game mechanics can be patented. But this will help us at one. It'll help with the Nintendo one. And it will help with... It'll help. I'm sorry, my brain froze for a second. It'll help with the Nintendo issue, the Nintendo versus Palworld patents, and it will potentially help set a precedent, or at least something that can be referenced to go forward and say, see, prior art exists for all of this, or prior art or obviousness exists for all of these. Patenting an idea is patenting obviousness in this case, and hopefully that will move forward and help get the USPTO moving on whether or not video game patents can be, or video game mechanics can be patented to begin with. And I can't begin to explain to you how happy I am that there's we can do something. We can actually do something about this. It's not just us sitting on the internet and complaining about it, impotently with nothing happening. We can do something, and that is amazing to me. I'm so excited about that. And finally, on a personal level, if you want, you can like and comment on this video and leave a hype, and that'll help the video do better, and that'll mean more people see this, so hopefully more people will be doing the search, which is awesome. And that'll help us get more information, but also on an even more personal level that's not all related to this, but would help me out greatly. I have a storytelling channel where I tell stories basically from my time in the military. I'm reposting a lot of the videos that used to be on this channel, where I'm telling stories a lot from my time in the military, but just from my life. And there's a playlist over there. If you can go over to that channel, subscribe to it, watch the playlist, help me get those watch hours, help me get that growth, help me get that channel moving, and hopefully help me get monetized on that channel so I can start paying my editor more and we could start dedicating even more time to this. That would be great. Thank you so much. I know I'm not really displaying it probably as much as it might be, but I'm incredibly stoked about this. I'm incredibly happy about this. But with that, fuck Nintendo.